Campaigning organisations want to publish hard-hitting publications that will attract public attention and advance their cause in a compelling way. Often this will involve exposing misconduct by individuals, businesses or organisations, or subjecting them to criticism. As you may have experienced, this important work may provoke a backlash from the people or companies whose reputations are likely to be affected. They may threaten legal action. Commonly, this will be a threat to sue for defamation. Having an awareness of the principles of defamation law should enable you to take steps to carry out your work in a way that reduces the risk of being sued successfully for defamation. The law of defamation protects the reputations of individuals and organisations against things that are written or said about them by other people. If a campaigning organisation publishes information that is likely to damage the reputation of an individual or organisation, it risks being sued for defamation. In this course, I refer to persons or organisations bringing claims for defamation as claimants. Whether or not a claimant can sue successfully for defamation depends on whether what is written about him or her can be defended by the publisher. Defences are covered in Module 3. You may have heard mention of libel and slander. These are simply two categories of defamation. Generally, libel concerns the written word and covers anything that is said in writing or semi-permanent form. So, for example, a defamatory statement published in an article, a report, or a press release would be a libel. Libel also includes things said during television or radio broadcasts, or which is published on the internet. Slander concerns the spoken word, for example, a speech at a public meeting, words shouted out at a demonstration, or something said in conversation. It is very unusual for someone to be sued in slander these days, and this course is concerned principally with libel. In this course, I use the terms libel and defamation interchangeably. You can see from the slide that there are three main things that are required for defamation to take place. For a claimant to have any chance of succeeding in a claim for defamation, he or she would need to show each of these things. They are 1. That there has been a publication which refers to the claimant, 2. That it has been published to a third party, 3. That the publication has caused, or is likely to cause, serious harm to the reputation of the claimant. If a claimant can persuade a court of these matters, he can bring a claim and seek compensation and other remedies, such as an injunction. Whether the claim will succeed, however, depends on whether the publisher has a defence. Defences are considered in Module 3. Each of these elements is introduced in the slides that follow.